I have 11:32, and I want to respect everyone's time who jumped on early. We may have a shorter conversation today because we've gotten so much work done, but we're here for as much of the conversation as folks want to have. I will go over the administrative items as we do at the start of every meeting. This is Barrick Abramson with Confluence Policy and Strategy Group, and this is the September 9th meeting of the COTA Rewrite Subcommittee of the 1296 Task Force on the Rights of Coloradans with Disabilities. A few norms as we start this. We don't have any members of the public on the Zoom call, but we are being live streamed on YouTube and some other platforms. So if you are a member of the public and do want to speak to this group, we will have public comment after we finish up the group's formal discussion. At that time, we'll need you to come over to the Zoom and let either Carrie or myself know. We do ask that members of the public leave their cameras off until it's time for public comment. And members of the subcommittee, if you're in a place where it is safe, comfortable, and appropriate to do so, that you have your camera on. I know we've got some folks in different places that make that a challenge, and we certainly respect that. We also hope, as I bring you into a conversation over the lunch hour, that everyone feels perfectly comfortable eating their meals in front of all of your colleagues and friends here. I know we're working over the lunchtime. With that, my last two requests will be, if you're a member of the subcommittee, the first time you speak, if you would introduce yourself by full name, in case anybody's watching this video or just streaming the audio down the road, and anytime after that, that you do introduce yourself by your first name anytime you speak. And finally, that we all refrain from using the chat function unless it's something urgent that you need to communicate with either Carrie or myself. The chat function can really become distracting, particularly for someone using a screen reader, but frankly, just distracts from the conversation and being able to listen to what your colleagues are talking about. With that, I'll go right into the conversation for today. Let me give a little outline of where we are and the plan for today. We have covered at this point all of the major topics that we were legislatively charged with. We've looked at emotional distress. We've looked at public accommodations and caps. We've talked about exhaustion and timelines for filing claims. You all have identified a number of additional issues. We've talked, for example, about the right to use medical cannabis off-site from work. We've zeroed in on a number of definitions that we think need to be incorporated directly into Colorado's law. That leaves us to review those items, then get stakeholder input on all of them and tighten them up so you're ready to put those recommendations forward for the executive committee. We'll also spend some time, if there are other unnamed issues that you think we want to touch on, either now or as we're getting stakeholder input. I do want to just ground us a little bit in how we're going to share these with stakeholders, and then what type of report we're looking to draft from this subcommittee. And then I'll ask, we've got Representative Ortiz on from the exec committee, so I'll invite him in. Just so everyone understands our current thinking, we're going to be framing this report in terms of what is the problem or the challenge that we're working to solve? What, therefore, is the recommendation you all are putting forward? For this group, it's probably just going to be straightforward of change this now. But I want to be very transparent with you about how other subcommittees are approaching it. Some of them are approaching it with, here is the problem, here is the intended end state, here is the North Star that we must be working toward in a definitive amount of time, and here is the first or immediate step. What I've heard from all of you so far, but I'm going to invite you to correct me if I'm wrong in any places, is all of these changes to the COTA law are things you're suggesting or contemplating be done now. So we'll talk about that as we put these all forward, but I don't see this group approaching much of it in a graduated way of change this piece now, but wait 5 years to get it right on another section, particularly with the nature of the conversations you all have had. So we'll go through each topic. I'm not going to read every idea because I've done that on past calls. So what we'll do is go through and just by section, solicit some input, feedback, and thoughts. I may seek to clarify where some of you have been in there entering some comments, and then we'll have that lingering conversation of what else do we need to discuss between now and when we draft the report. Before I go into that, though, let me turn first to Representative Ortiz, and then I believe the ARC of Colorado, maybe Elizabeth Moran, and if so, I'll invite both of you to speak. Rep Ortiz, any words of guidance, encouragement, or just things you'd like us to cover today?
No, this subcommittee has been the example since day one. So just want to thank everybody for their talents and their time. Just haven't been here for a while, so excited to hear how far you guys have come and where you're at. So thank you guys so much.
Thank you. Ms. Moran.
Indeed, Barrick, it is Elizabeth Moran, and I would echo what Representative Ortiz said. I'm just thankful to be here and hear the discussion. Thank you.
Great. Thank you. Do any members have any questions or things that you want to put on my radar or things that you'd like to clarify before we go into today's discussions? Okay, seeing and hearing none, we will dive in. And as I said, we've got 90 minutes on the calendar. You all have been so efficient with our work that unless you come up with 27 new ideas that we weren't charged with, which I will leave the door very much open for you to do, we may have a shorter call. But I'm going to go kind of block by block. The first one that we covered, and this goes back into the spring, was around emotional distress and the ideas relating to that. Rather than reading through each of those, does anyone have any questions or comments as you look through those? And I'll remind that these are also these are among the ideas that we have shared. Okay, maybe it's going to be easier if I go to some of the ideas, places where I know we've had some things raised. One thing was under miscellaneous. This was my error. I had suggested we protect the right to use cannabis, period. Mr. Montoya corrected me that should read right to the use of medical cannabis outside of the workplace. And just to remind you all where we landed on this conversation, a number of folks raised concerns of how do you accurately measure level of intoxication of cannabis, THC, even if it's outside of the workplace. So where we landed on this idea, and this is one that we haven't discussed the exact wording of, so I will spend some time on this. It reads as follows. Convene a working group of medical experts, public safety officials, individuals with disabilities, employers, and cannabis experts to develop recommendations for protecting the rights of individuals with disabilities to have a protected right to the use of medical cannabis outside of the workplace. Groups charged would recognize exclusions such as public safety and should examine multiple means of measuring levels of intoxication to protect out of work use while protecting employers' right to prevent workplace intoxication. So let me pause there after reading what are two very long sentences and just get thoughts on, does that feel consistent with the discussions we have, and do folks have ideas on the wording that you may want to revise? Lauren, jump in, please, and then Andrew.
Well, on this topic, as well as the previous topic, I think, as I read through them all, I think you captured the ideas that the group talked about succinctly and accurately. I mean, I will turn to my lawyer friends on the call to make sure that we really captured all of the wordsmithing correctly. But what seems to be missing to me is the areas that are problematic. And so I'm reading this as these are the ideas that were discussed, but I just would caution if this is something that the public is going to be reading and thinking that this is a recommendation so far, that it should be noted that there's some challenging issues here that have still been unaddressed. And in the medical marijuana case, employers or government contracts that require levels of security, for instance, that at this stage from a federal level disallow medical marijuana use. That makes sense?
Lauren, it absolutely doesn't. And let me offer a couple of thoughts. One, we are being very intentional in how we frame this when we share it out, that these are ideas. These are not yet recommendations. And I'll be sure that we do that on here as well. You raise and I'll make sure the questions are specific enough to solicit where people either have concerns, where they have considerations, where they may have ideas that they want you all to consider if you develop this into a recommendation. But as we've done on some others where I've noted the challenge, I'm happy to include a note about concerns raised about whether we have accurate means of measuring with efficacy, and the fact that no law that we change can supersede issues like government contracting and security clearance issues. Andrew, let me bring you in both on what you had your hand raised about and if Lauren sparked any additional words of wisdom for us.
Thank you, Barrick. This is Andrew. I actually put my hand down because rereading things, my concern kind of went away. I think I may have misheard or misconceived something as you were reading. With respect to Lauren's point, I think making note of that is absolutely worthwhile. I also would like to say that I'm not sure that with the phrasing that we have here, I just want to make sure that we're not setting this up so that there's a working group that's going to talk about things, but nothing will ever necessarily come from it, because, something like judging the level of impairment from marijuana is something that's been going on for, a discussion that's been going on federally and internationally for the past umpteen years at least, and we don't seem any closer to that. So I don't necessarily want to wait until there is something final before we allow Coloradans to use medical cannabis without facing backlash.
So and we can probably get into a lot more detail in the recommendations, but I also want to honor what you're saying. Do we want to include in here that this group would be tasked with making recommendations for policy within 12 months, or that this would be a time finite group that is charged with making specific recommendations on how to implement? What are your thoughts, Andrew?
Thank you, Barrick. This is Andrew again. I think that's kind of where my head is some sort of timeline, and also making it clear that the charge isn't simply to study it, but the charge is to figure out how to get it done.
I will so revise that. Does anyone else have any thoughts? Tom Wheaton, please.
Thank you, Barrick. Tom Wheaton here. And I missed the last meeting or two, so I might be not familiar with this specific case, but I got the sense that this issue seems outside the scope of our charge, or is this within the scope? I'm a little confused because I think we handled some other things that were really relevant to what we were trying to do with the rewrite, but I just didn't get a sense this was part of it.
And I may invite our bill sponsor in on this one. What I can say is there was nothing in the legislation that said address medical marijuana. It did say to look pretty holistically, as I interpreted it, at issues of anti-discrimination laws and any type of laws affecting Coloradans with disabilities. And when this issue originally came up, going back to last December, the issue was the specific medical needs of individuals with disabilities that were prevented by existing law. Rep Ortiz, are you in a place where you can jump on the audio and address the question of this if you've intended this to fall within our charge? I know he's multitasking a bit, so I may bring him back in. Let me go to Andrew and then.
Could you repeat that again, Barrick? I'm sorry.
Yeah, so Representative Ortiz, the question was, as we're looking at this issue of medical cannabis usage by individuals with disabilities, the question was, does that fall within our purview? And my interpretation was, we weren't explicitly tasked with it. Members raised this as a question of rights of individuals with disability to seek the care that they are medically prescribed.
Yeah, here's what I'll say about that, because I was reflecting a lot, because Lauren brings up great points, Andrew brings up great points, is that we have able-bodied folks that are on opioids or stronger stuff than medical marijuana that don't then lose their job, that aren't being tested while they're at work, right? Like, so for me, this discussion needs to go back to equity, right? If it is a medical necessity and you are able to do your job, then someone discriminating you simply for using it, that is discrimination. And that's kind of what I feel like falls under the purview of this task force, right? Like, there are people that are on nerve blockers for nerve pain that have stronger side effects than medical marijuana, right? There are people that can still do their job. Let me be very clear. There are, and like, not to out some of my colleagues, but there are colleagues that are on recreational marijuana under that dome, right? That do their job. And that, so I just want to call that out. Like, yes, we're talking about discrimination. When it comes to issues, I'm also sensitive about the discussion around areas of security. And, I don't know that it's our job to do the federal government's job, because I don't know that marijuana has the same stigma or ability to leverage against someone that it used to in the 70s and 80s, right? I don't know if a foreign government's going to be like, oh, well, we know about your weed smoking, so give us a secret or we're going to out you. Marijuana is legalized in a lot of states now, right? So that's what I mean when I say that. Like, I don't think that's our job to study that. That's something the federal government needs to look into, but it is our job to talk about discrimination when it comes to medicine that people with disabilities might need just to be able to function and be productive.
Thank you. Tom, does that address your question sufficiently?
Yes, maybe I was just politely trying to avoid the issue, but I appreciate it. Thank you.
Yeah, thank you. Let me go to Andrew and then Cindy on this.
Thank you, Barrick. And this is in further answer to Tom's question. What really raised this issue is there was a case in Colorado shortly after medical marijuana became a thing that went and decided that employers could fire someone for using medical marijuana off the clock. Just about the vast majority, if not all other states since then have gone the other way. So Colorado's kind of behind the times in that respect. So that's really why we want to get it done. And as Representative Ortiz said, people with disabilities should be able to use the medication of their choice, especially if the others have more severe consequences.
Thank you, Andrew. Cindy, please.
Yeah, so what Rep. Ortiz is talking about is something I brought up last time when we discussed this, which is I'm not sure why medical marijuana is any different than, some of the other drugs that may affect someone, potentially their performance and what an employer would decide as, maybe the essential functions and the safety of the job. So, for example, a school bus driver, there may be concerns about that person using certain types of medication, whether or not it's related to a disability, a medical condition, whatever, if they're operating operating a vehicle. And it comes down to, it is a decision that's made oftentimes by a doctor who says, yes, employer, I understand, this is the nature of the job this person's doing. I feel this person's okay to do it or not. Or the employer says, we don't allow any employees to drive, let's say while under the influence of certain types of pain medications and so forth. So there's a part of me that says, why are we separating out medical marijuana? On the other hand, many times people who have disabilities have medications such as medical marijuana, other types of things that are related to their disabilities that do, people discriminate against them because of their medical use and because of them having a disability. So if there's something that we need to do to strengthen that by adding it to CADA, I think we should consider it, but it's not going to be a standalone. It's going to be in conjunction with other parts of the law.
Understood, and great points. Thank you, Cindy. Cindy, I'm going to have a follow-up question for you, but Ian, while I've got you, as I know you're juggling your own medical appointment, let me bring you in.
Yeah, thanks, Barrick. This is Ian Kalmanowitz. I just want to make sure that what doesn't get lost in this discussion is that the proposal is to allow the off-duty use here, not the on-duty use. And so, I mean, I just want to make sure that everybody remains clear that this is no different than the off-duty use of any other prescribed medication. It's also no different than the off-duty use of any recreational substances. And if you're a school bus driver, there's nothing about your job description that prohibits you from engaging in the off-duty use of any prescription drug or alcohol. You just can't do it on duty.
Thank you, Ian. Cindy, I want to come back to you because you brought up this balance we're trying to strike of this speaks specifically to cannabis. It's a larger issue. Is there a way that you were envisioning maybe we want to expand this idea or add a second idea of what individuals should be permitted to do off duty?
Well, I do want to go to the point about off duty, because whether or not certain things, even alcohol, if a person could drink before they're on duty, but they might have a certain amount of alcohol, in their bloodstream, which will impact their ability to operate a motor vehicle. Same is true with cannabis. In fact, it stays in the bloodstream longer. So I think there is some things to be considered here. I frankly think that there probably does need to be some feedback from a committee on this issue in terms of overall how it affects, what an employer can or cannot do. If it relates to people with disabilities, as in, we're not talking about the use of just medical marijuana, but we're saying a person who is using it and it's related to their disability, this can then lead to discrimination. If we need to do that, then I would support bringing about a recommendation to have a committee, such as we talked about, to look at that. But it's not just about disabilities. That's my concern. The scope is bigger, much bigger than what we're charged with.
Completely understand. Thank you for that clarification. And I just, for those who may be following the document, I added another comment that not only should this group be charged with making recommendations, but that they should look at, examine and consider other state, national, or other studies and work going on into both the effects of cannabis or THC and of efficacy in measuring impairment, which I think a couple members here have highlighted. That's work that the federal government has been trying for years. I know we've got multiple medical studies. We've got groups in Colorado looking at it. We've got at least one of our major fire departments who is examining off-duty use and permissiveness there. So we're not charting altogether new ground, but as I'm hearing from all of you, some of those efforts have been lingering for a while. And what I'm hearing from you is you want tangible recommendations put forward.
Mhm.
Other ideas and thoughts on language you would want to see on this cannabis idea before we share it with the public? Andrew, I don't know if I saw you motioning or just adjusting. You're good. Okay. Let me go to a next topic where I really need all of your guidance. And Andrew, I appreciated you making an additional note next to the definitions. And I've even, since you put that, revised the language. Andrew's point was that we are not simply incorporating federal definitions in all cases. That some of them, this was about incorporating to protect against misinterpretation or the changes to ADA, that we wanted those definitions directly in our Colorado revised statutes. Not all of them, though. And as Andrew reminded me in a comment, some of these are more about taking case law and precedent and incorporating that. Some of it was a lot of the input. Right now, we have 5 definitions that we're proposing be incorporated directly into CADA: disability, qualified individual, essential functions, interactive process, which remember we had some conversation about recently, and fundamental alterations. Here is my question for you, and I want to just have some open conversation, is more about the process of us developing these and putting them forward. My question for you is what we want to share with stakeholders versus where you want to share that we're working on these, and leave it to your group, the exec committee, and ledge council to hash out the exact definitions. As I see it for stakeholding, we can go, I see really 3 areas along a continuum, or 3 approaches along a continuum. At the most basic, we could say, these are 5 terms that you are considering defining in Colorado revised statutes with no definitions. At the other end of the spectrum, you could offer full legal definitions and say, these are the definitions we're considering. In the middle, you could say, here are the 5 terms we believe need definitions, and here are some of the key aspects or terms that we think need to be included in that. What I'm going to invite you to discuss is the following. If we go full legal definitions, will people other than lawyers and legislators be able to digest it sufficiently to offer meaningful input, or will we be making the definitions inaccessible? At the other end of the spectrum, if all we do is put the terms, are we being so shallow that it's not meaningful to offer input? So I'll open it up to your thoughts on the approaches. I want to respect our lawyers and non-lawyers alike in how we solicit input on where we're now getting, which is pretty legalese sections of this. Andrew, please jump in, and then Lauren, I'm coming to you.
Thank you, Barrick. This is Andrew. Probably not surprisingly, as an attorney, I am all for the legalistic, full-on definitions. And that's because when you're talking about definitions in particular, the devil really is in the details. You know, moving a word from here or there or removing a word, things like that can have huge consequences. And to the extent that we are the folks that have our hands around what we're trying to do, have our heads and months of work in this, I think, excuse me, spelling out those definitions in as much exactitude as possible would be the way to go. But I think further, you know, with respect to providing a little bit more input for some of the non-legal legal folks that are going to be reading this, that providing some additional explanation or additional thoughts may be helpful, like we're talking about with some of the other things. So, for example, with the definition of disability, the proposal that we've come up with is to simply incorporate the federal definition. But I can tell you that in and of itself is pretty verbose and has a lot of moving parts and such. But telling the public, hey, we're simply incorporating the ADA definition. It's, you know, it's not a lot of new tricks that we're trying to incorporate here. It's full-on incorporation, versus with some of Ian's proposed definitions that incorporates more of the case law, explaining, hey, you know, we're incorporating these aspects of the statutory definition, but want to make these changes, or, you know, these updates based on our recommendations or case law, whatever the case may be. I think that might be the way to go. So we're making sure that we're putting forth the best language that we can, but everyone knows why we're doing it and, you know, our justifications essentially.
Thank you, Andrew. And just to bring everyone back to the last time it was snowing for the first time in Colorado, and we got together in November and December, there was a lot of work you all did in drafting those definitions. So we are not working with a blank slate. There's been a lot of smart work you all have contributed. So we can certainly pull in that full legalistic language along with some of those background notes of plain language explanation. Let me go to Lauren, and then I think I saw Rep Ortiz pop his hand up.
Yeah, this is Lauren. I would just echo what Andrew said. Actually, I think, you know, having the definitions as proposed by this group but it's important to have the rationale so that lay people can understand what the change would mean.
Yeah. Great, thank you. Representative Ortiz, did you want to weigh in on this?
And not to sound like a broken record, but also echo that, like exactly what Andrew said, I think is going to be most helpful to the executive committee in providing, using your legal minds that have been involved in this work, exact language, and then a synopsis or explanation of what the rationale and justification and the kind of end result is in doing so.
Great. So what I will do is we will pull together for these 5 terms. Some of them, as Andrew said, you know, things like disability, we're incorporating directly in. Some of them we're getting a little more reliant on case law, on precedent. And someplace you all have added your own color to them. I think the place I will probably lean back on most of you, or on you the most, is particularly around interactive process and making sure we get that described right, both in the legalistic sense and the rationale. I think the rationale may be easier for me, but Andrew, Ian, our other lawyers, I'm going to lean on you to make sure I get that one right. Are there any other terms that folks feel are missing at this point? And again, I want to emphasize, I said this the last couple of times, when we get all the feedback from all of the other committees, I'm going to be bringing all of that to you in case it raises legal definition or COTA questions about some of the things other ID groups are proposing, whether that's information being shared about accessibility features of housing, or what we're requiring commercial operators of recreational facilities to ensure accessibility. I have some question that some of that may require all of your eyes on it. But until we do that, are there additional terms that anyone wants to suggest we should define? Okay, door stays open, because you still have the ability, even after we've shared these, and gotten public input, you'll start tightening them up and you'll have the opportunity there. We've got one more where, Ian, and unfortunately Spencer's not with us, but Ian, you got tagged by Andrew on one. This relates to public accommodation laws. And right now, one of our ideas, item 2 under ideas relating to public accommodation, is to examine and consider incorporating into Colorado laws the DOJ Title I regulations. And the question, Ian, was whether we should also be looking to incorporate EEOC regs as well. Going back to our whole discussion about what's happened with Supreme Court rulings and what weight's given to regulations at this point.
Yeah, hey, Barry, this is Ian Kalmanowitz. I do think it would be a good idea to take some of the EEOC regulations and incorporate them. I did in some of the definitions that I had prepared cited to the EEOC regulations as the source for those definitions. But I absolutely think it's worthwhile, taking some of the other definitions and incorporating them into the statute.
Then with your permission, which I'm unfortunately for you asking in front of everyone, I'd love to draft some of that language and make sure I'm referring to the right ones and bounce it off of you.
Of course, absolutely.
Wonderful, thank you. Okay, with that, we have reviewed all 4 of the big topics that this group has put forward so far. My other big topic of conversation, or 2 of them, will be the what else category, since you were given that large charge of other things that may be in the interest. Then I want to talk about how we're going to go to stakeholders with these after some great input from the exec committee. But let me open it up to the big question. Are there topics specifically related to Colorado's Anti-Discrimination Act or other laws that prevent and provide enforcement for discriminatory acts that you feel we haven't talked about, either that we should touch on today or that you want us to just pin to make sure that as we're sharing ideas with stakeholders, we come back to some topics that are outside of these narrow pieces? Andrew, please.
Thank you, Barrick. This is Andrew. I'm not sure. I mean, this is probably very premature, just even bringing it up. But since you're opening the door that broadly, I figured I would go ahead and mention it. We've had a couple of issues related to another part of the Colorado Anti-Discrimination Act related to the rights of parents with disabilities. There's, I want to say it's section 804 or 805 that sets forth the rights of parents with disabilities in things like dependency and neglect hearings. And I don't have any firm proposals, anything like that. All I can say is we've had some issues arise where it seems that courts aren't necessarily according the right amount of deference to the requests for accommodation, things like that, and situations aren't necessarily playing out the way that the statute intended them to. Again, very premature, just raising that we may want to take a look at perhaps strengthening or clarifying some of the obligations of courts when they're dealing with parents with disabilities in things like custody or dependency neglect proceedings.
Thank you, Andrew. One, can you remind me, did you say section 804?
I believe it's 804 or 805. I can take a look.
That's okay. I'm just trying to scribble some notes here. And given where we are in our process, and it's certainly fine to bring these up, do you believe that we could develop some ideas, or is this where I'm seeing a lot of the other subcommittees identifying issues for further research and investigation, that whether it's CDU or a continuing version of this body should continue to look at that?
I honestly, I hadn't really given it that much thought either. It's just kind of, an issue that's kind of started, percolating a little bit. I think, as I sit here today, I think either way would work. I mean, this certainly does deal with the civil rights of people with disabilities in Colorado. On the other hand, we are already pretty far down the road, and this may be something that would be better addressed through, a separate process or separate legislation. I really don't have much of an opinion on that as I sit here today. Just kind of, again, raising something that's been percolating.
And I'll tell you, and Cindy, I'm going to call on you in just 1 minute. As your facilitator who has seen the work go into this group, and I know the attention these recommendations in this task force will get because of all of that, I would hate to miss out on the opportunity to put forward at least whether it's an idea or the call for an idea. If it's okay with all of you, what I'd like to do is at least draft an idea that we might share around strengthening parental rights to see if we can't get some stakeholder input on that. That could lead you to either developing a recommendation or to saying this still needs more work. I don't want the fact that we didn't get to it today to rule out you all possibly wanting to make a recommendation. Cindy, let me bring you in on this or other topics. I'm not sure what you had your hand up for. Jump in.
Yeah, this is Cindy. Well, actually, first I want to agree with Andrew in the sense that with regard to custody and with regard to abuse neglect, there are some, significant problems with the way that the law is currently working. And I do think it would behoove us for a committee to look at how we can strengthen, CADA to make it work. Just in the last few months, I have worked with, a woman who's considered deafblind who lost custody of her children simply because, she didn't have the accommodations. She eventually got it back with the help of community organizations. However, the fact is she should have never lost them, and it was really related to the fact that she had disability that interfered with her ability to communicate effectively. There's a lot about the disability laws that we have in place that don't work, and I've said this before, and I feel like enforcement and accountability is something I don't think that we've done enough to look at what is working, what's not working, and what can we do to strengthen it. I don't think we've looked at that piece enough.
Thank you, Cindy. And there was an issue I was going to bring up later in the call, but because we've now kind of hit the direct intersection, I'm going to bring it to all of you now. I don't know, and as I bring this, I don't know that this is a place for the rewrite subcommittee to address, but we've hit two intersecting points. I'm going to raise it with all of you. I had a conversation with a member of another subcommittee who Shannon said it's fine that I shared that it was a discussion with him. Shannon is deaf and raised some concerns about the medical advice and treatment that parents of a deaf child are receiving and wanted this considered. Shannon's experience and said that this was echoed in the deaf community was that pediatricians and general practitioners default advice to the parents of a young child who is deaf is go get cochlear implants. And his feeling was that was in ways disrespectful to the deaf community and wasn't providing full medical advice, fully rounded medical advice, and that the parents were limited in where they could go to get advice. So Shannon wanted, whether it's this group or the government services subcommittee, to contemplate if there's a role for government, whether that's at CDHS or HICPUF or the Commission for the Deaf, Hard of Hearing, and Blind, to consider a navigator role or a support resource for parents of deaf children to get informed advice from the community with lived experience. Rep Ortiz, as I'm talking, your hand is up, so let me get you in before I go to the rest of the group.
Yep. And the reason why I raised my hand is because I met with an organization. I'm not going to name the organization right now for professional reasons, but pretty much seeking to somehow utilize state resources to push essentially this. And my red flags went up like crazy. I absolutely went up like crazy because, I hear that complaint about, well, like that's cochlear implants and no other option, that is single-minded. If the state is going to be involved in anything or offer up anything, it needs to make sure that all options are being considered. And on some level, it's ableist. On some level, it is absolutely ableist. Just being quite frank. You're talking about a minor that cannot make that decision for themselves. And if the only thing that the parents are hearing is cochlear implant and nothing else, because it makes their kids normal, that, that's why the huge red flags went up, so this is definitely something that I feel like falls into the purview of this task force, especially if some of these organizations are going to be pushing to try and in the future where there's, not a representative David Ortiz to try and utilize state resources to push, that, then this is something y'all need to discuss for sure.
Thank you, Representative Ortiz. And this is one that I'm not sure where it fits neatly into one of our subcommittees, whether that's about the Government Services Committee, who talks about accessing government services. I didn't really see it fitting there. It seemed the closest to this group, who was about protecting the rights through Colorado revised statutes. But I would be curious to hear from our lawyers on that. Is this about including something that requires holistic and a disclosure of all options, or is this creating a new government service that is this navigator? And I'll invite lawyers from a legal lens and everyone from just a gut check lens of should we be putting an idea forward? And I will also say, as your facilitator, this is an issue that if you tell me is about a fundamental right and it doesn't happen to fit neatly into one of our boxes, I'm willing to make one of our boxes a little oddly shaped and make it fit. But I would welcome thoughts on this issue, and from what Rep. Ortiz shared, that it seems there's groups trying to leverage state resources for a single solution. Andrew, please.
Thank you, Barrick. This is Andrew. So just to make sure that I'm understanding, essentially, we're saying that private medical doctors are recommending to parents of kids who are deaf that they get cochlear implants, and that's like the one and only solution that's being recommended?
That's correct.
Okay. So, I mean, yeah, that's absolutely a problem. And I think that's something that we, can and should look at tackling. But my hesitancy is that we can't be prescriptive necessarily. We can't tell doctors what you have to say or what you must do. Frankly, that would encounter some First Amendment issues, and, that would likely be unconstitutional. But I think that we could absolutely recommend putting additional state resources behind less ableist ideas to get into parents' hands and the general public hands too, and including medical professionals. I mean, other than throwing money at it, putting a huge pot of money out there and essentially, putting resources out saying, hey, if you have a kid who's deaf, here are all the other options, and insinuating those into into medical practices and such. I'm not sure how we would actually go about doing anything about that in any real way. I mean, I'm more than happy to talk options and, frankly, creating that big pot of money. But I'm not sure how we would be able to get into, the medical advice that an individual doctor is giving.
Understood. And while they didn't come to me with a request, the idea that was shared with me is, could the state provide some type of, as you described it, Andrew, resources, or they talked about a navigator to help parents get access to information of all options. They did wonder if we could require medical doctors who are discussing any of the option to refer parents to the availability of this state provided information on all options. Cindy.
Yeah, this is Cindy. So, there's a couple of things going on here. I mean, there is, for example, mandatory screening when a baby is born in terms of hearing. And there's actually two kind of checkpoints to determine if a child has hearing loss. And I'm bringing this up because, this is sort of the flag to a doctor. There's a problem. But there's also many processes that already exist for early intervention for children, whether they're born with vision loss or hearing loss or any number of other types of conditions. But the problem is that parents aren't necessarily referred to those automatically. There's no required process that says, if you have a child who has hearing loss, you will then be referred to this entity or that entity who will then, kind of help you navigate. What are the options available? Systems navigation is the second step, but the first step is identifying the problem and saying, okay, now here's a resource that can tell you, here's the different sort of steps you can take. There's an intervention process. Here's a place where you can get knowledgeable about your options and so forth. And I think what we need to do is look at what happens when your child has, vision loss, hearing loss, other types of disabilities. Where can we make sure we mandate some sort of at least referral to information, a referral to early intervention, at least some assessment from a professional who will then, it's up to them to give those options to people. But the second thing is to realize that it's not just children, it's people who develop that at some point. I actually work with someone who has been blind all her life, but suddenly, just due to a medical condition, lost their hearing. And there isn't a place to go to get help unless you sort of know where to go. You don't go, for example, DVR unless you're looking for help with a job. There's actually pretty limited places to go. So there's an overall intervention process needed and a systems navigation process needed. And in some cases, the development of resources. And it's not just children.
Thank you. You have made it both more complicated and, to me, more important for me to. But as I listen to you, it's clearly important that we at least begin addressing this. So I'm going to draft some language that really focuses on the resources, the referrals, and Cindy, to your point, acknowledging this is not just a children's issue, that those who have things later in life are going through the same challenges. This does bring me to my other issue raised by another subcommittee to bring to all of you, and it's also a medical issue. This is one that, and they are fine with me sharing this, that Julie Reskin and Chanda Hinton are both working on, and I think it resides more over at HICPUF than other places, but I want to bring it to all of you. Their challenge sounds largely one around enforcement, but it's an issue of providers who offer visits that are accessible. And the concern that, particularly when it comes to Medicare and Medicaid providers, there are too many whose facilities are not accessible, and that prolongs the ability and the timeline to get an appointment with a provider, and it limits those, and that this is happening largely in violation of the ADA, which you won't be surprised that most of the subcommittee's ideas and recommendations are falling into category 1, enforce the darn laws we already have. Category 2, educate people about those laws, then inform and educate and provide some navigation supports. But I wanted to bring this one to you, particularly as we're having this medical conversation. The issue is around government-funded health care through Medicare or Medicaid, where the providers are not offering accessible facilities. And Ian, I'll bring you in, and then Cindy, because I saw you smiling and nodding, I'm wondering if you want to join in here, but let me get to Ian first with his hand up.
So this is Ian Kalmanowitz. Thanks, Barrick. I think this is something that speaks exactly to everything that we've been working on for these last many months, because these government-funded medical providers used to be subject to suit under the Rehab Act for this kind of a violation. And under the Rehab Act, pre-Cummings, these suits could be brought because you could get emotional distress damages. I know that Andrew can speak to the specifics of representing individuals who wind up either being denied or deprived of medical care because of the lack of accessibility issues. But this, I mean, the fact that this is being talked about at another committee, I think speaks volumes to exactly the need for all this work that we've been doing, because this is precisely what we're proposing these fixes to address.
I appreciate that, Ian. And to be clear, we first brought it to the Government Services Subcommittee because they're addressing government services. But I also felt in that you are looking at the laws protecting individuals against discrimination. We wanted to talk about it here. Cindy, your thoughts?
This is Cindy, and yeah, I mean, access to medical facilities is a huge issue. Um, sometimes people think about, well, being able to getting in and out of a place because of, maybe the need for a wheelchair ramp or whatever. But for folks who are hard of hearing and or deaf, it's effective communication. For people who are blind, it's, digital accessibility, and it's a huge, huge issue. I mean, there's almost always something that gets in the way of finding accessible medical resources for me and almost anything I need to do. I'm almost always going to have to go get help from somewhere because it's just not there. Which is why I go back to enforcement and accountability, because we're so far from being there.
So, Andrew, I'm going to bring you in, and I'm going to throw this to you and to the whole group. Is this about us needing to add additional enforcement mechanisms? Is this about us naming in CADA that this is a right? Or is this a right that we simply need to provide more resources to the enforcement of? Andrew, I'll go to you first.
Thank you, Barrick. This is Andrew. So I've got, frankly, several thoughts about this. First of which, I mean, just kind of starting at the basic level, it sounds like we're talking, with respect to Cindy's point, largely about physical access, but there is other access, such as digital access, like Cindy, rightfully raised, that should be, can be, and frankly, under the law, already should have been addressed. As the law exists now, medical providers, just like any other private business, or if it's associated with a government agency, any other public entity, have an obligation to avoid discrimination. But when you're talking about something like physical access, it gets a little bit squirrely, because then it has to do with the age of the facility. It has to do with when that medical practice began operating in that facility. Was it that medical practice or whatever entity was there before that created the inaccessibility that exists now? If, for instance, a medical provider decides to move into an old building that has never undergone remediation, then it may be fully inaccessible to anyone with any sort of mobility impairment, but not a violation of the ADA. To go a step further, it could be that, yeah, you can get in the door, you can get into the exam room, but you can't transfer onto the exam room table because the exam room table is too high and it doesn't adjust. Here recently, I want to say within the past, few months, the Biden administration has put forth guidelines for regulations related to medical equipment. And those should be, I forget exactly what stage they're at right now. If they haven't been, officially adopted, they're on their way to being officially adopted. That will in fact impose for the first time ever some sorts of requirements on things like exam tables and such, but that's only for diagnostic equipment. So, I mean, even that is fairly limited. So, I mean, getting back to the root issue of, frankly, getting in the door, even before that, getting an appointment scheduled on their online platform, something like that. The law already requires certain things, but we certainly can, and I think should, strengthen it. For instance, we could make it so that in Colorado, medical providers have to comply with, or have to ensure that they comply with, the most recent standards, regardless of when the building was built, or who built the inaccessibility, or when they moved in. Similarly, Colorado is on the cutting edge of creating digital accessibility requirements for public entities. We could very easily impose those same requirements on medical providers. I'm sure we would hear from all of them, the sky is falling for all of this, but that's what we're going to hear from everyone. And, I think particularly when you're talking about medical things, it's even more critical. One, that's a huge issue for people, but two, that's something that people with disabilities encounter a lot more than people without disabilities. So to the extent that we can strengthen Colorado law to make medical places have to comply with the more strict standards, I fully support that. And that's something that would go above and beyond what we already have.
Thank you, Andrew. Rep. Ortiz.
Yeah, I gotta echo that. Like, I cannot, it always makes me so incredulous. Your literal fucking job is to tend to the sick and dying. And those that are, even if you're completely able-bodied coming into the hospital, you might end up in a wheelchair while you're going through treatment or whatever is going on. And to not have the infrastructure to accommodate the literal, even able-bodied people that you're supposed to be serving that might have a temporary disability while they're there at the hospital, to me is disgusting and incredulous. Like, that is not just a violation of the ADA, but that is negligence on their part. So I absolutely and wholeheartedly push that, you know, that this subcommittee look to create stronger standards around that. I mean, look what we did with web access, right? Look what we did. And then the DOJ, you know, supported that. And so you're welcome, all of Colorado, because we gave you a head start on what you're gonna have to do anyways when it comes to web access, right? So this can be another way that Colorado can be leading the charge and leading the pack. Because I guarantee you, if we on the federal level keep pushing, you know, this administration and the next one to make this a thing, DOJ might be coming out with another ruling that supports what's already going to be happening anyways, and we can help our hospitals get ahead of that and lead the way in the nation.
Thank you, Representative. So what I'm hearing, and as I will on these others, is I'll draft some language and share it with all of you to respond and strengthen it before it gets shared with the public. So we may have a rollout part 3 and 3B, but this would be around the accessibility of medical providers. And we started 6-8 minutes ago talking about government funded, where I heard this evolve, and I want folks to correct me if I heard incorrectly. Is that accessible care is such a huge issue, we can't limit it just to government funded providers. We need to require all medical providers, or we need to put out the idea of requiring all medical providers to comply with the most recent standards for accessibility of their facilities, and share an idea of requiring medical providers to meet the state digital and online accessibility standards. Andrew.
Thank you, Barrick. This is Andrew. I wholeheartedly agree with your, you know, the way you encapsulated that. I am thinking about this, and I think perhaps we want to go a little bit further. And, you know, I'll put this out to the group to require that government benefits offices comply with the most recent standards as well, because the same thing that I was talking about, physical access, applies to government entities as well. It could be that a government, you know, a Medicaid office in, you know, some small county is terribly inaccessible. There's no reason for that to remain the case. If we're requiring medical providers to bring their, bring their facilities up to the most recent physical accessibility standards, I think we can and should also require that of benefits offices, be it, you know, unemployment or Medicaid, whatever the case may be.
Any member want to react? And I know this is one of those, we have a lot of times where we have an idea percolate and then we really get into it on the next conversation. This is an interesting set of ideas that it really is going to live at the intersection of the government subcommittee, which is about the ability of Coloradans with disabilities to access government services they need, and medical access, which may include those government services, but includes it even bigger. So I will probably take the government benefits offices idea to the government services subcommittee, and that may become a joint idea that's made even stronger. Other thoughts on this topic of the ability to access medical care and government benefits? Okay, what I have for my homework, Ian, are you jumping in or just on camera? Jump in, my friend. We don't have audio from you. You're unmuted, but we're not hearing you. No audio yet. I'll fill time while. No. Okay, we'll come back to Ian, or Ian, I may give you a pass to drop me a thought in the chat if you'd like to. My homework right now this week is to draft language on the following 3 additional ideas from today. One is the rights of parents with disabilities. And I will look and make consult with Andrew. Are we talking section 804 or pieces of 805? But looking at strengthening the obligations of the courts in things like custody and neglect, but also generally. One idea, the next idea I'll be drafting around, Cindy, yes.
I'm sorry, when you were saying parents with disabilities, I assume you mean children who have disabilities, but we were also referring to parents who have disabilities when we during our discussion.
No, and please correct me then. I actually, in my notes, I had just written down the rights of the parents with disabilities, not of parents of children with disabilities. But are you correcting me that it should include both?
Well, my question is more around the assumption was when we say parents of disabilities, I think we're assuming parents of individuals with disabilities.
I'm
But we
sorry.
also referenced conversation around parents who have disabilities. So for example, abuse and neglect cases, a parent who is deaf or deafblind, they don't have the accommodations. Their children might not have the disability, the parent does, but they still need the same protections enforced.
And that may have been me reading poorly. My note was rights of parents with disabilities. Maybe I should reword that to rights of parents who have a disability.
I think
But I
it's
was-
two separate things.
Yeah.
So there's parents of children who have disabilities, but it's also parents who have disabilities. So there's actually two separate groups that we talked about.
Got it. I am correcting to include both.
And the children may be adult children who have disabilities. So it's individuals, parents of individuals who have disabilities
Thank
is
you.
one section. Okay.
No, I appreciate this. Andrew, yes.
Thank you, Barrick. Excuse me. Thank you, Barrick. I just wanted to clarify that my first point was the parents with disabilities, and that's under Section 805. So there is the statutory requirement that, courts ensure that parents with disabilities get accommodations while they're going through the process, things like that. And that's just not always happening from what we've seen through some cases. I think the children with disabilities, including, adult children with disabilities, so to speak, may fall under the second point, which is about providing additional information to said individuals so they can get the medical care and such. Excuse me, and such. Yeah. Thank you.
Thank you. And then, so to that point, the next idea I owe all of you as my homework to draft is around medical advice for parents, and it started with deaf children, but we're talking more broadly about advice for parents of an individual with disability. They may be child, they may be adult children. And there we're talking more about state programs and resources, interventions, referrals, and holistic advice on the options. And then this third idea that I owe all of you to draft is accessibility of medical providers, which we ended up expanding in our discussion to accessibility of the medical providers and government benefits offices, where I'll draft some language and also collaborate with the Government Services Subcommittee.
This is Cindy. I think, when you have medical providers, I think you're going to say medical providers and services. I'm thinking about dialysis, for example. So providers, maybe providers includes that, but I'm not sure if it's, generalized enough. Do we need to say providers and services, medical services? I don't know. It's a question.
I'm happy. I think I will let lawyers and ledge counsel get it absolutely right down the road. I will expand it so that the public understands we're talking about providers and services.
Okay.
To your point.
Perfect.
If nothing else, I'm going to shift gears into the stakeholder engagement side of this. I want to be very clear. We had originally intended over the summer to roll out ideas on this rolling basis as you develop them. We put up the first round and then the second round of ideas from 3 of the subcommittees. And I will tell you that over the first 6 weeks, we got 6 comments. And when we had a conversation with the executive committee, the feedback that we got from them and from some stakeholders was it's just a lot to intake and to know when to weigh in. And if I'm going to reach out to my networks, tell me the time to do that, not the 17 times you want me to try that, Barrett. So what they suggested, and we are now working with Jenny and Aubrey and Katie at Dora on, is developing, the idea was 1-pagers. I'm going to tell you, these groups are all too thoughtful to have 1-pagers, so they're going to be 2-pagers for each subcommittee's ideas that have really the shortened, plain language. Here are the ideas and the why that these subcommittees are putting forward. You can then access the more comprehensive versions. But folks wanted some really easy to digest and access shortened versions from each subcommittee. And they wanted to roll those all out at once so that everybody could reach out and say, hey, the 4 subcommittees have all generated dozens of ideas that they now need our input on, rather than trying to hit people up 5, 6, or 7 times. Part of that was a sense of urgency or creating one because they're all now out. And part of it was just making it truly accessible in every form. So we're now working on that. My intention is to have all of those by the end of next week so that we can distribute the documents, and they'll be in PDFs, they'll be in plain text, and they'll be up on the website in compliant formats and accessible formats. We are then going to ask all of the subcommittees, sure, prioritize the areas that you've got the expertise or the lived experience in or have spent your time on, but we're going to ask everybody to highlight the work of the overall task force and all of the subcommittees, and invite your networks, whether it's business community, individuals with lived experience, other lawyers, other folks out in the communities, to weigh in on any or all of the ideas they want. And I want to be clear on that last point. Someone may want to weigh in on 3 of the ideas from this committee, 4 from recreation, 2 from another, and every single idea from the government services. I want people to feel welcome to respond to as few or as many as they would like, and not feel obligated that I can only respond if I have in-depth thoughts on every idea offered. So I will draft some language. I will share that all with you and welcome your input. But does this approach feel right to all of you? And as part of that, if we get these 2-pagers or accessible versions in multiple pages available by the end of the next week, how can Carrie and I best support all of you in sharing those? What would you need from us to support that effort, in addition to the language, the documents, some links, and some graphics to post on social media if you'd like? What else would be useful for us to support you?
This is Alana Veras. The one question I have just for especially for the 2 pages as we're sending them out, some of the stakeholders I would like to be able to send this out to primarily speak Spanish rather than English. Will we have multiple languages available, or will it just be available in English?
I don't know the answer. I will get one for you. I saw Andrew nodding. Cindy has raised her hand. Alana, let me see if we've got access to some translation services for at least the 1 or 2 pagers. And where we don't have the ability to translate everything, if I can make sure that there are easy to access resources for that. Just full transparency, we hadn't discussed that, so I'll need to get an answer for you.
Thank you.
Andrew, did you have your hand up and then back down? No? Okay. Cindy?
Yeah, this is Cindy. I think what would be helpful is for each of the 2-pagers, if you want to call it 2-pagers, just a 1 or 2 line summary at the top of sort of how this list came to be. Because while we all know, as we're part of the subcommittee or those who are part of the executive committee, they sort of understand the process, but John Q. Public, we're asking them to take time out of their day. They have no clue how this came to be and why is it important. So just a little 1 or 2 line summary, and then when is this needed by, so people can immediately see, okay, this is what we're asking, this is why it's come about, here's some thoughts, and here's when we need it by, right up front. That would really help a lot.
Great. I appreciate all of those ideas. What I will do is create some language that can go on the top of each subcommittee's document that is super brief. I will also provide probably just a 1-paragraph overview about the 1296 task force as a whole, so folks understand that full scope. And we will set a date. I will tell you, my intention is to set the dates 3 to probably 5 days ahead of your next meeting so that we can close the input. Carrie and I can synthesize it all together, get it out to you for you to be able to preview in advance of our October call. which is when we're going to have the discussion as a group of, here's the ideas we started with, here's what the public had to say, where is our thinking now, how do we shape this? So we'll put the intros together of how we got there, we'll put the language together about what this task force was all about, and we'll set a date that lets us give a couple weeks for input, but make sure we close that input in time for you to review it. Any other ideas? Just know that I will continue to be somewhere between the gentle supporter and the aggressive nudge and harasser to make sure that everyone gets these ideas to as many people as possible. And Carrie and I are here to be your help and support in doing so. We don't have anyone for public comment. We got through everything pretty quickly. So I'm happy to give everyone 15 minutes back. Before I do, I want to invite first Elizabeth and then Rep. Ortiz in with closing thoughts.
I really appreciate, this is Elizabeth Moran. I really appreciate the rich discussion and the engagement and the depth with which you all are really diving in to say, is this even, what fits where and what are next steps? So I don't have anything to add other than to say thank you. I really appreciate all of your time and engagement.
Thank you, Elizabeth. Rep. Ortiz, you get final words.
Yep, from the very beginning, you guys have been the standard when it comes to subcommittees. So, when some of the others were a little unsure or had unsure footing, I always pointed back to this group. So thank you so much for being amazing professionals. Thank you so much for not just pouring your heart and souls into this, but offering your knowledge, your expertise, and offering what's going to be real tangible solutions for Coloradans moving forward. Some of you here might know how much it's going to mean, but in case you don't, I'm here to voice it to you as someone that lives with a disability. This is going to be huge. What comes out of this subcommittee especially is going to be huge to finally securing, one, a 34-year-old law, but also trying to secure basic equity and basic access for those that live with a disability. So thank you. This work is important. Excited to see where it ends up.
Aubrey, I saw your hand pop up, I think. Or was that an errant click? I guess not. I know I have hit buttons randomly during Zoom calls, so I can't say anything more than Rep. Ortiz did, other than our gratitude for the honor and privilege of supporting all of you in this work. I will get to work on these 3 new ideas you all identified today, as well as pulling the language from everything you've done on definitions together. We'll get that circulated back out together, and we will continue to work with Ginny and Katie and Aubrey on getting some of these short form documents together to circulate. With that, my thanks to our executive committee members and to all of you. We'll be in touch by email over the next week. Thank you all very much.